Here, this is Anthony Smith. I'm an Ohio resident, and in their revised code, again, like I said, psychiatry usurps the law, U.S. law, through public welfare. Title 51, Public Welfare. Chapter 5122, Hospitalization of Mentally Ill. The labeling of mental illness is a fraudulent prerequisite, pseudo-legal, extrajudicial buzzword. It's doublespeak, Orwellian doublespeak. It's a lie that they use to take away all your basic American constitutional rights. And I'll prove it to you right here. This is what you call criteria to be judicially hospitalized, falsely imprisoned, detained by psychiatrists, not the state, because the psychiatrists have more power than the state does on every branch of government. Every single branch, for whatever reason. And I can sit here and prove it to you. Affidavit of mental illness, the state of Ohio, undersigned residing. Now, the judge at the probate court will sign off on this after a mental health agent, a psychiatrist, or the psychiatrist agency under the rule of the psychiatrist has evaluated, or what they call probate pre-screened, a person. So here's the thing, and this is illegal, and they even write it in the law, clinical psychiatric law. You're not supposed to be able to probate somebody unless you're seen by a psychiatrist. But what they do here in Ohio is they have this third-party organization where they have something called a probate pre-screener, and they decide whether or not you get affidavitted or not, which is illegal. It's breaking the law. And they do it anyways. They allow all this stuff because, again, like I said, they supersede all law. Psychiatry supersedes all law. It's what you call antinomian. N-O-M-I-A-N. It means against or outside or above the law. Okay. Please specify category below with an X. Now, they do this to me every time. The judge gets the probate pre-screener. Pre-screeners lies. And they mock it up and they make it seem like each of these is true and real. Now, I was running out of memory. This is why they did it too. I was running memory, or were able to do it. I was running out of memory on my phone to record me and my state and what I was doing and what I was saying to them. And I hadn't had time to get my self-defense surveillance equipment together yet. So that when they call these people on me, they have me probate pre-screened, I can record and have evidence on my side against them. Because here's what they do. They give you 72 hours to be evaluated after they have effectively took you into the hospital. And they give you what's called a respondent's copy of the affidavit. In their records, they destroy the record of them ever detaining you, of them ever putting an affidavit out for you. I don't know what's legal about that or why that's illegal. So in other ways, they're doing documents fraud, and then they're destroying the evidence that they're doing document fraud, and it's all through the law, sanctioned, because psychiatrists have mind controlled them and manipulated and gave them all that power to do that. Now, in child services and child protection, they keep records of everything that goes on forever. And they will destroy, in psychiatry, they destroy the documents of what they were doing immediately, so that they're no longer liable, because it's a fraudulent, criminal, fascistic scheme, an anarcratic scheme, where some people get democracy other people get fascist dictatorship and totalitarian mind control and slavery. Now, I did not represent a substantial risk of physical. This is where you put an X down and say he or she meets the criteria. If there's an attempt at suicide or serious inflicted bodily harm, they'll mark that off. They'll mark every one of these off. You know why? Because, and they'll lie about this too, and if it's not a lie, they'll change the law to suit their lies. I'm serious about this. They've done this to me for over 20 years. You can believe me, or you can look it up yourself. But they'll also destroy the evidence to that. Now, I'm under guardianship, and under guardianship, you have to meet all criteria in order for someone to probate you. So that means, and they did probate me on June 12th, 2023, I believe it was, or June 10th. Okay, so the thing about that is they had to commit the greatest fraud that they had to documents fraud to get me in this time, which is say that I was all of these things, even though I'm under guardianship and I'm fine. Under guardianship and being under surveillance, psychiatric surveillance, because that's part of this, part of slavery, surveillance and projecting or profiling someone's identity, taking away their decisive decision-making power, vetoing it, and then also characterizing their own identity without their consent. Represents a sample risk of physical harm to others manifested by having recent homicidal or violent behavior. Okay, these are criteria. And like I said, I'll link in the description the laws that this is breaking when you lie about this. Serious physical harm and other evidence of present dangerousness. The reason why you need evidence of this is because of something called O'Connor, a court case called O'Connor versus Donaldson, that occurred in 1975 with a landmark case, which changed what's called the dangerousness standard. That is, you can't affidavit someone, hospitalize anyone against their will unless they present a substantial risk of harm to themselves or others. Now, there's one last criteria which says you could be gravely disabled, but that is a fucking ridiculous, absurd. It's what you call vague, legally vague term, gravely disabled. Just like mental illness is a legally vague term and an excuse or a rationalization or a justification for what they're doing. In legal terminology, people that are competent in the law know that psychiatry and psychiatric law would all be expunged because it would all be what they call void for vagueness. You can look this up, void for vagueness. Because that means that there's not enough evidence because the legal understanding is not clearly defined enough to be actionable. Represents a substantial and immediate risk of serious physical impairment or injury. This is grave disabled. So the self is manifested by evidence of being unable to provide for and or not providing for basic physical needs, and they lied about this as well. Provision for such needs cannot be made immediately available in the community. And I know the respondent company has all of these already because I know how the law is. I looked it up how it works in Ohio where I live. If you're under guardianship, you need all these criteria, even the A, B, I, whatever the hell all this stuff is. So they're saying that I'm completely crazy. I meet all the criteria for all this, which is impossible. How would you even handle somebody that was in this state? It's a blatant lie. And you can hear me now. You could see the evidence that this is not how I am, that this doesn't describe me, and that I shouldn't be allowed to be detained. Would benefit from treatment for mental illness and his need of such treatment as manifested by evidence of behavior that creates a grave and imminent risk to substantial rights of others or the person. Now, rights. Substantial rights. See, now this is the trickiest part because what they're doing with this is they're breaking the 14th Amendment, because O'Connor versus Donaldson, the dangerous standards, works on the 14th Amendment. And because if you break that law, it deprives someone of life and liberty, which is outlined in the 14th Amendment of the Constitution, and your equal right of protection and all like that. Now, what they're saying with this essentially is that if you have beliefs that are inconsistent with the status quo or the government or whatever religion is that the person and peoples follow that are persecuting you via psychiatry, that you're risking their right to practice their religion and their freedom simply by having ones that are not consistent with their own. That's what that means. What else would it mean? In other words, because otherwise it would be thrown out, and this wouldn't be even on here because it would be void for vagueness, right? So if you ask a law professional in psychiatry and mental health, well, what does this mean? How could you be how could you be an imminent risk to someone's substantial rights? Or society's rights abroad? This is counter-revolution. This is trying to get people to vote for only one person and coercing them. Because if that's what the USSR did to political dissidents. Would benefit from treatment as manifested by evidence of behavior that indicates all of the following. Persons likely to survive safely in the community without supervision based on a clinical determination. Again, this is non-clinical because a probate prescreener is a social worker, a licensed social worker, not a doctor, not a psychiatrist. Again, this is why it's illegal what they're doing. This is what I'm talking about. The person has a history of lack of compliance with treatment. Compliance is a slave term. Look it up. Compliance is a slave term. It has to do with America when slavery was legal. I mean legally. They would say if you was through the probate court, which is the same court which handles psychiatric detentions in psychiatric slavery, they would use the term compliance. If the slave does not comply with its master, blah, blah, so on and so forth. Following applies. I'm going to continue on here. At least twice within 36 months prior to the filing of an affidavit seeking court-ordered treatment of the person under Section 5122.111 of the revised code, the lack of compliance has been a significant factor in necessitating hospitalization in a hospital or receipt of services in a forensic or other mental health unit of correctional facility, provided that the 36-month period shall be extended by the length of any hospitalization of incarceration of the person that occurred within the 36-month period. Within the 48 months prior to the filing of an affidavit, court-ordered treatment of the person under section of the revised code. The lack of compliance resulted in one or more acts of serious violent behavior towards self or others. Serious. So they're confessing that they're saying that I'm all this with no evidence, all the evidence to the contrary. Provided that the 48-month period shall be extended by the length of any hospitalization or incarceration of the person that occurred within the 48-month period. And then when they get you in the hospital, they're able to mark all these off again, even though you're in there and you're doing nothing to anyone. Under the threat of security with guns and tasers and batons and police. And the deputy sheriffs bring you in. The person, as a result, which are complicit in the psychiatric conspiracy now, since, I think it's 1980 something, when they instituted what's called 1987, 1988, the Memphis model with the police cooperation with the psychiatric conspiracy of race war genocide against me and my people. The person, as a result of mental illness, is unlikely to voluntarily, where they lie on us and say that we're violent and that we're going to be violent. It's Jim Crow. It's what you call psychiatric Jim Crow. The person, as a result of mental illness, is unlikely to voluntarily participate in necessary treatment. In other words, Them being psychic, they don't hate themselves, and they don't see that their experience of reality on a psychic level is the result or symptom of a non-existent disease which they can't prove exists. In view of the person's treatment history and current behavior, the person is in need of treatment in order to prevent a relapse or deterioration that would be likely to result in substantial risk of serious harm to the other. So, what they're telling you here essentially is that psychic abilities are a threat to the human race, the same way that racist Americans authorities said that the black race was a threat to the white race, therefore a justification for all their legalization and laws surrounding their ownership and enslavement. They're saying that telepathy, they're blaspheming telepathy, saying that telepathy is a harm to the human race and to the person who is the telepath. And they're defaming them, calling them first-rank symptoms of a non-existent disease called paranoid schizophrenia. In the view of the person's treatment history and current behavior, the person is in need of treatment in order to prevent relapse, deterioration, blah, yada, yada. Name of the party filing the affidavit further says that the facts supporting this belief are as follows. Yeah, because they have different belief systems. And the First Amendment says you're allowed to have different belief systems. It's called a religion, which this is proof that psychiatry is a religion and that it is a theocratic psychiatric slave state that you live in, not a democracy. Because if you by chance or design become telepathic, it will tell you that your telepathy is not real and that is the symptom of a brain disease, which they have no proof of. It's a moral judgment, not a scientific one, which is religious. These facts being sufficient to indicate probable cause of the above said person, the person with mental illness, psychic, telepath, not mentally ill, should act to a court order. The undersigned represents a trial court or a prosecutor who has described in Division B, which is this is slave, this is where it goes to the probate court, this is the enslavement of the psychic race. Because they're saying that these people are your slave masters and you're saying that these people own you as chattel property. The same way they did in slavery. You can look it up. Probate court dealt in chattel slave, and this is exactly it. They're treating us like property. And this is telling you right here where they're treating us like property, legally, and how they're able to supersede our American freedoms in the Constitution because they know we're not human. And they're saying fraudulently that we're human, and then they're dehumanizing us and taking away the same constitutional rights that everyone else has, the same way they did with the blacks. Same way. Native patient's last physician or licensed clinical psychologist. Patient's last physician or licensed clinical psychologist. Okay. The name and address of respondents, legal guardian, spouse, and adult next of kin are the following constitutes additional information that would be necessary for the purpose of determining resident. Dated. Signature of the party filing the affidavit. Sworn to before me and signed in my presence on the day and year above. So this is swear documents, which means they're committing federal crimes when they're swearing. Signature of probate judge, deputy clerk, or notary public. Waiver. I undersigned party filing the affidavit hereby waive the issue and services notice of the hearing on said affidavit and voluntarily enter my appearance herein. This is beyond June 10th or June 12th. Now they're going to destroy this document. Signature of the party filing so that they're no longer liable for it, of attempting to enslave, torture, and murder you under psychiatry, genocidally. This Legislative Service Commission presents the text of this section as a composite of the section as amended by multiple acts of the General Assembly. This presentation recognizes the principles stated in RC Revised Code 1.52b that amendments are to be harmonized if reasonably capable of simultaneous operation. That's updated March 17th. Now look how recent this was updated. March 17th, 2023 at 1:23 p.m. This is part of the conspiracy, how they do this, how they move around, they amend, they change things so they can become more fascistic. So they can take away more rights more easily. So they can be in cahoots with Big Pharma.